On August 26, 2024, a federal judge paused the new Biden immigration law. Let's talk about it. What happened? What are your options? On August 26, a federal judge in Texas actually put pause on the new Biden immigration law after a lawsuit brought by 16 states, including obviously the state of Texas, asking the judge to pause the law. Now, for recap, we have to talk about what exactly is the Biden immigration law. Specifically, it's an executive order. It's an executive order because it's coming from the president. The president is the executive, right? And obviously, on June 18, 2024, the president actually issued this executive order allowing the spouse of U.S. citizens who have not been inspected and admitted, as well as the stepchildren of those U.S. citizens who are married to their spouse who as well did not enter the United States with a visa. Now, there are three criteria if you are the spouse of a U.S. citizen and if you were not inspected and admitted. You have to show that you have a 10 years continuous presence in the country as of June 17, 2024, because obviously it's not open-ended, June 17, 2024 being the date that you need to remember. Number two, you will have to show that you have a legally valid marriage to a U.S. citizen as of June 17, 2024. Number three, you have to show that you are a person of good moral character and you do not have a disqualifying criminal conviction. This is very important because not every criminal conviction will render you ineligible, but some will definitely not allow you to pursue your application. Now, the process between June 18 up to August 19, when the form became available on USCIS website, that's the process that it took for USCIS to prepare the form, to actually also tell us what will be the filing fees, and obviously have the executive order published is what is called the Federal Register. All of this allow now the application to be ready on August 19, meaning USCIS actually inform everyone that they will start accepting application on August 19, 2024. If you want to apply for this particular program, the form will be form 131F as in family. Now, you can only apply for this form online. And the filing fees is $580. Now, starting August 19 up to August 26, everything was actually available and open. Now, on August 26, a federal judge issued this order putting a pause. How long is the pause? That's a pause of 14 days. Meaning basically the judge actually granted a temporary order, meaning that once you have a plaintiff, and the plaintiff was actually spearheaded by the state of Texas. The plaintiff actually brought the suit before the court, and this was not done by happenstance. It just happened that this particular court and this particular jurisdiction is a jurisdiction that the plaintiff believed that will be more friendly to hear their claim. And obviously, when you bring a claim before the court, you have to show that you have standing. And then the argument that the plaintiff put forward, here we're talking about the state of Texas and other states, then what they put together and they put forward as an argument was actually to show that DMD immigration law will result obviously, according to them, in an increased cost to the state, meaning that the implementation, obviously, of the program. Here we're talking about the PIP program, the family, unity, that will actually result in a increased cost. That was actually that. They say that also they argue that the illegal immigration was a disaster for the state of Texas and other states, that it was also that it violated the Constitution. This is an argument that we hear before, that was brought again a few years back, by the state of Texas and other states, when it came to DACA, right? Meaning they did say that as well. Now, we have also obviously a group, meaning that we have a group that was led by the Coalition of Human Immigrant Rights, and that was actually also with a group of undocumented immigrants. They filed a motion to intervene in the lawsuit to defend the program, because you can also, even though the case actually, the lawsuit was filed by the state of Texas and other states against the federal government, you can also have third party who can actually file motion with the court, to be heard. That's basically what we had. Now, what is parole in place? When we think about parole in place, when you think about it, it allow actually the person who is eligible and who is qualified to apply actually for parole in the United States without leaving the United States. Because somebody who is in the US without a legal status is actually somebody who cannot even move forward and actually adjust their status as a permanent resident. Meaning that with parole in place, they will be granted a legal status. And with this legal status, then they will be able to move forward and apply for permanent residency. Because the parole in place does not give you a green card for the moment, but you need that in order to have parole and to have a legal status. Then you will have also an I-94. Don't forget, the I-94 is given to any person who comes with a visa, and that also, this I-94 include what is called a duration of stay. The person who actually was not inspected or admitted does not have a duration of stay, does not have a legal status. And this is basically what the program is attempting to correct. Because the idea when they're talking about family unity is for the people who have been in the United States for years, that have built their life, have their family, in order for them to come out of the shadow. Now, obviously, for DHS, for the federal government, they're arguing that this program is consistent with fundamental American value. Now, for you, what does that mean? What exactly are you supposed to do based on the fact that we have a pause? The temporary restraining order has been granted for 14 days, meaning that the expiration will come on September 9. Now, the judge has the discretionary power to actually renew, but he gave 14 days during which USCIS is allowed to continue to accept the application, number one. But number two, they cannot process those applications, meaning that I encourage you, if you are eligible, you should submit your application online. You should continue to gather all your documents and then go on the USCIS website and submit your application, because it will be accepted by the service, but it will not be processed. We have seen this before with DACA, meaning this is not something that is new. Also, to apply for the program, there is no restriction. As long as you're eligible, you can actually submit your application, meaning that you do not face any restriction. And then obviously, if after 14 days, the judge actually, lift the stay, because for the moment we have a stay of 14 days, then USCIS will resume the processing of the application. And then obviously, all of the people who apply during the stay, they will not be penalized. They will not be barred from consideration, meaning that it is actually in your interest to go forward and apply for actually consideration. Now, you have to be ready and to understand that this is not over, because here we're talking about a temporary stay. Maybe the stay will be lifted. If it is lifted, you can also expect that there will be litigation, because the stay is not even the judge actually hearing the case on the merits. No. But the judge also has already issued a scheduling order, meaning that that's what happened when you go to court and then you want to have your case heard, then the court will give you a schedule about, obviously events and things that both parties are supposed to do. The judge actually issued the schedule, and he wants to hear, from both parties as regard to, obviously, summary judgment, it seems like it will be before October 10th. I think the idea is actually to see how the case could move forward and can be heard even before election day. But you can be certain that what's going to happen, probably whoever loses, the case will end up before the Fifth Circuit, and that's the Court of Appeal of the Fifth Circuit. And obviously, it can go all the way to the Supreme Court. We've seen this for DACA, which means that it will not be surprising if you see the case USCIS saying, yes, they're processing the application, and then there is a development on the case, they have to stop, and then the processing actually is resuming, which means that you should definitely prepare yourself and submit your application if you are eligible, because this is actually expected. And obviously, for those of you who are following my page, actually know that this is something that we knew that was coming, meaning that when we see what happened with DACA, we're very not surprised to see exactly this will be coming our way. Now, when you prepare your application and you want to submit your application, you have to be careful, because there are a few things that are ongoing. Number one, be careful about scammers, because there is a rumor out there stating that the new law applies to people who have been in the country for 10 years, yes, and who have U.S. citizen children. That is not true. That's not true. There is another rumor as well saying that the law was expanded to include another category of person. That is actually not true. It is not true. You have to be careful. If you hear something like that, you can be sure that this person is probably trying to mislead you. Now, something that was not anticipated was actually a certain question that actually have been found in the form I-131F, as in family. What exactly is this? There is a question in the form where you will be required to persuade the USCIS officer why should you receive the parole in place, based on either urgent humanitarian reason or in the interest of the United States. This is actually something that is very close to actually an application for a waiver for an I-601 or I-601A. Meaning this is something that's a burden of proof that is actually higher than just submitting the proof that you're married to a U.S. citizen and also evidence of continuous presence. Meaning that you will have to actually persuade and make the case as to why you should be granted parole in place. And I can tell you that is the reason why they're talking about on a case-by-case basis. This is something that is not actually as straightforward as one may believe. That's not the case. Meaning that I will tell you that you need to think about this when you submit your application, obviously online, because that's the only way to do so. You should do it carefully. You should not just submit an application and just write something, for example, about why you should be granted PIP without evidence. You need to have evidence to support your claim. And failure to do so It's actually stated in the application. If you fail to submit evidence, the chances are your application will be denied. It will be denied. Meaning that's why I encourage you to be extremely careful. We will be having other video explaining exactly how do you prove, this urgent humanitarian reason. How do you prove that it's in the interest of the United States to have your parole in place granted? My name is Annick Koloko. For us, immigration is personal. Thank you for watching, and don't forget to subscribe to this page, and see you soon. Bye.